Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903. All right, well, 2022 is going to be a critical year for America. AMAC, the Association of Mature American Citizens, along with their nearly 2 million members. The fight to stop out-of-control spending in the president's Build Back Better scheme is far from over, and Congress is plotting more legislation that could hurt our seniors. The midterm elections will be a battle for freedom versus socialism. Unlike liberal groups, AMAC is America's conservative, action-oriented 50-plus organization fighting hard every day here in Washington and across the nation for our seniors. So I'm urging you to choose AMAC now. You will receive all of the great membership benefits, including AMAC discounts on hotels, travels, and restaurants, and your membership will support your conservative values. So go to amac.us/Ellis. That's amac.us/ELLIS to become an AMAC member now.
As a constitutional law attorney, former senior legal advisor, and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
And welcome to another episode of the Jenna Ellis Show. I'm Jenna Ellis, and there is so much to talk about with the latest Supreme Court opinions, and of course the left is freaking out. And we had a great discussion earlier this week about the concept of federalism, and now we need to talk about more in depth the concept of procedural versus substantive due process and how we can champion the Constitution and the limited powers that are actually given to the federal government, and why Justice Thomas is absolutely right in his concurrence. So who better to bring on to discuss these issues than my good friend Mike Donnelly, who is an adjunct professor at Patrick Henry College and an expert in all things constitutional law. So he's the one that I go to when I have conversations, and we love to discuss these types of things. So Mike, thanks so much for having this conversation on my show.
Well, Jenna, you are too kind. There are lots of people who are experts on the Constitution, and I like to think of myself as somebody who's informed. But, we have to discuss these things because they're challenging concepts. We've gotten ourselves into a situation in this country where I don't think any one person could be an expert on the whole Constitution, which is a little bit not what the founders intended.
Right.
Actually.
Right. We should all be experts on the Constitution because the Constitution actually isn't that long. And if we look at the specific limited powers that are given to the federal government, there's actually not that many. Article 1, Section 8 is pretty clear, and it's very, very, very limited. But actually, as I described in my whole episode on what is federalism, if you haven't gone and listened to that, by the way, everyone listening, go and listen to that, because we talk about the Constitution in context, what is federalism, and this whole idea that there are different words and phrases that the Supreme Court picks out of the Constitution, and they build whole doctrines around it and these long, complicated tests. And that's not actually what the Constitution provides for. So let's get specifically into the Dobbs opinion. Of course, the first holding that is really important is that Alito, writing for the majority, said that the Constitution does not provide a right to abortion. That's pretty easy because the Constitution doesn't provide any rights to us. It's God, our creator, that does, not our government, right? So first, let's start there, Mike. So let's unpack that a little bit.
Well, sure. So, as Justice Thomas says in his concurrence, he says substantive due process is an oxymoron that lacks any basis in the Constitution. So let's get geeky. I was at Patrick Henry, we have a constitutional law camp today. I've got 60 students between the ages of 14 and 18, and we're talking about these constitutional concepts. And what 14 to 18-year-old comes to a constitutional law camp?
Me, I did.
You and people who care about our country,
Yes.
who care about our Constitution, right?
Yes, everyone
So
should. And actually, if you're listening and you have a 14 to 18-year-old, then maybe look into the Patrick Henry Con Law Camp. I've been invited to speak at a few of those, and it's been great. But yeah, everyone, especially our up-and-coming next generation, should be understanding the Constitution and why we're proud to be an American, beyond just like, the hamburgers and hot dogs and the barbecues.
Well, that's right. And as I said to them this morning, I said, look, how can we fix problems if we aren't willing to identify and then admit that we have problems? And so, Justice Thomas does that there. And this idea of substantive due process, what exactly is he talking about? So let's see if we can unpack that cogently, because it's 125 years of opinion upon opinion upon opinion, which Brutus in Article 15 back in the Anti-Federalist Papers, when the founders were debating the Constitution, called it out. He said, this is going to happen. So if you're interested in, a little prophetic utterances from our founders, go read Brutus 15. But what is substantive due process? Substantive due process has its roots in the 14th Amendment, the Due Process Clause of the 14th Amendment, passed right after the Civil War for good reason, because, in some states, Black people who were newly freed were not being protected in their rights to own property or to vote or to exercise the rights that they should have. By the way, these were men, because it wasn't until the 19th Amendment was passed that women got the same treatment in terms of the franchise, in terms of voting. But following the Civil War, we passed the 14th Amendment, which says no state shall deprive a person of life, liberty, or property without due process of law. And it was about 15, 20, maybe a little bit more down the road before the Supreme Court started actually using that phrase, due process of law, to start striking down state laws, which is what the substantive due process clause has been used, or the doctrine of substantive due process. And it comes to us in two different sub-doctrines, if you will. There's the doctrine of incorporation, and then there's the doctrine of implicit rights. So what the Supreme Court has said, and they started with implicit rights, actually, in parental rights, actually, something that I support. I support the idea of parental rights being recognized. But the question is it in the Constitution? You won't find the word parental rights in the Constitution, just like you won't find abortion. Okay? But the Supreme Court said, well, this word liberty that's in the 14th Amendment must mean something. And if it means anything, well, it means that Oregon can't require that every child go to a public school. So they struck down a law that Oregon had passed that was voted via referendum, not even through their legislature, okay, in 1925. So that's kind of the Supreme Court defining the word liberty and saying, well, we're going to find liberty. And they've gone on to do that. And that's where the right to abortion comes from, which comes out of the right to privacy that they also discovered in the Constitution, because you won't find the words privacy in the Constitution. They had to impute it, and we can talk about that. But that's the implicit rights, okay? Then there's these explicit rights that we all know and love. The First Amendment, the Second Amendment, the Fourth Amendment, the Eighth Amendment, right? We're all happy about, the Supreme Court striking down New York's silly gun law, saying, they have a discretion to refuse to issue a concealed carry permit, under the Second Amendment. And so the Second Amendment is explicit. It's in the text of the Constitution. And so the court said, we're going to incorporate those rights that we find in the Constitution explicitly in the text of the Constitution. And we're going to use that same idea of substantive due process, no state shall deprive a person of life, liberty, or property without due process of law, to apply that definition of liberty to the states. And Justice Alito talks about that quite a bit in his decision, which, by the way, it's a masterful decision. It is so well written. Anyone could read it, even non-lawyers. If you're wondering, oh, these Supreme Court opinions, I can't read them, I can't follow them. This one, you can.
Yeah.
And I encourage you to read it. I encourage every citizen to read this decision in Dobbs because it's so well written.
Right. It really is. And so, okay, so let's contrast this idea of substantive due process rights to procedural and define for us the difference.
Sure. Yeah. So the idea of substantive versus procedural, right? So these words also occur in the Fifth Amendment of, in terms of protecting due process. So what the founders meant when they said due process, they really meant procedures. Okay. It doesn't say you can't be deprived of your rights. It just said you can't be deprived of your rights without due process of law. And so what that meant was that people had to have, a right to a trial, a right to have witnesses at a trial, a right to have an attorney, some of those rights which are mentioned in the Bill of Rights, but there are others that are not mentioned in the Bill of Rights, which the Ninth Amendment recognizes also. So these notions of due process, that you had to be treated fairly, everyone had to be treated the same way, this idea of the rule of law, and that if you were encountering a situation where the government was infringing on your right, taking property, they couldn't do that without giving you just compensation. And they couldn't just say, well, we're going to give you $1 and we think that's just. They had to give you an opportunity to dispute it in a court, and you had to have a remedy. So due process. It didn't mean you couldn't be deprived of your life, because if you committed a felony or capital crime, you could be deprived of your life. You could be executed, but not unless you had a trial by a jury with a lawyer and an opportunity to appeal and all of those things that come with due process. Same thing with liberty, but liberty is one of those terms that's a little bit more amorphous. Well, so then the court came in and said, you know what, it can't be just process. There have to be these categories of rights that you can't be deprived of unless we, the Supreme Court, believe that it's okay. And that's where the idea of substance came. So they've read substance into the word liberty to protect a whole host of rights, parental rights, for example, which, okay, we can talk about that. Right to privacy, and the right to abortion, which came out of that. And there are others that, have come down. And Thomas, he says, we got to go back and revisit all of that. Okay. Justice Alito is very careful. It is huge. I mean, he's only one justice, and he's going to have to convince all the other justices to go along with him. But Justice Alito takes very careful measures to say, look, we're not talking about everything here. He says, because Roe v. Wade was about the potential life or the actual life of a human being. And he says that makes it unique. And so he was very careful to try to assuage the concerns that a lot of people have been raising that, this means, they're going to go after Obergefell and homosexual marriage, and they're going to go after, other things.
Which they should. I think they should. And whether or not they will, though, isn't the question before the court today. And you're right, that Alito had a very measured opinion here. But the point of how they have manipulated, they meaning, former Supreme Court precedents that Thomas once revisited, are because they took this language in the 14th Amendment that, as you pointed out, was actually just at the time that it was ratified, only applicable to men, which is hilarious because nobody ever talks about that in terms of, the intent or the scope or whatever. But they tried to then, these court rulings, read into the language in order to create a wider jurisdiction of the federal government to then go and inquire into the adequacy and the rationale of state laws in a way that the Constitution never intended, and certainly the 14th Amendment never intended. So that's where Justice Thomas, in my view, is absolutely correct, that we need to return the federal government to being as limited as the Constitution actually requires.
Absolutely. And you and I have talked about this so many times, and you know that I'm a huge fan of federalism as it was intended. We know that the founders did not intend for the Bill of Rights to be exercised against the states, because there's a case called Barron v. Baltimore where the Supreme Court actually said the Bill of Rights does not apply to the states.
Right.
I mean, so hello, guys, you talk about precedent and stare decisis. Let's go back to that. I mean, that was the founders' idea. And, there's another case I know that you mentioned to me, the Kennedy case, the Coach Kennedy case, and that has a whole religious aspect to it. Well, let's talk about the Establishment Clause. Does anyone in this country, a few do, but does anyone realize that when the Constitution was ratified, that there were state established churches? Okay. And the First Amendment says Congress shall make no law. That did not apply to the states. And the states themselves, over time, they got rid of their established churches for a variety of reasons. But one of them, I think, was that you couldn't be in government office unless you were a member of the state church. And over time, they said, we probably shouldn't do this. So they stopped doing it, and they got rid of the established churches. And that's, but that kind of happened on its own.
Right.
And so this idea of the Bill of Rights applying to the states, no, never did. And I talked to so many of my friends and neighbors who are clueless. They don't know this. They think that, this is just what the Supreme Court does. It just is in charge of everything. And when I explain to them this, they're like, wow, I had no idea. And that's what we've got to do. We've got to let our folks know. So I'm so glad people are listening to this, and hopefully this is new to them. If not, this is where we've got to be going, folks. We've got to put the federal government back in its box.
To let know about this are our state legislators as well. And you and I, Mike, have talked about a number of things that state legislators aren't really aware of, that they actually have more power than the federal government. And it was intended that way under the concept of federalism, that your elected state and local leaders are closer to you, not just in geographic proximity, but also in terms of your vote and in your districts, than Washington would ever be. And wouldn't it be amazing if Washington was so limited to what the founders actually provided in Article 1, Section 8 to Congress, and in Article 2 to the presidency, and we had the executive branch that got rid of all of their unconstitutional agencies? That was probably like 99% of them. And the Supreme Court actually said in all of its opinions, sorry, this is a state issue. We're returning this issue, returning that issue back to the people and their elected representatives. Then guess what? Our elected representatives in the states, including the governor's mansion, would be so much more paid attention to, and that would be so much more critical than anything going on in Washington. And that's actually how the founders intended it. And I hope that this new shift will awaken America to recognizing state sovereignty and federalism in a whole new way.
I hope so too. The states are sovereign entities. We have a system of I call it dual federalism, where we separate sovereignty, which is an interesting subject. We were talking about that a lot in my con law class today, the idea of sovereignty and popular sovereignty, and that our nation is based on this idea of government by the consent of the people. Well, is that what's happening right now? Are we really governing ourselves, or are we being dictated to? Right. Okay. The federal government is the biggest threat to our liberty, whether you want to look at it on a moral basis or in an economic basis. I mean, there are how many trillions of dollars of debt they spend? I mean, how do we fix that? One way we fix it is by saying, more, okay, and reducing the size and scope and extent of the power of the federal government.
Repeal the 16th Amendment.
Getting rid of the income tax. I am a huge fan of the fair tax, repealing the 16th Amendment. Yep. The income tax is one of the main reasons that the federal government has been able to become so powerful, because they wield the spending power, which, oh, by the way, the Supreme Court has let them get away with spending things on things that they should not be able to spend money on, just because it says so in the, it's the general welfare of the country. Unless it's in Article 1 of the Constitution, in my opinion, the Supreme Court should not be letting Congress spend money on those things.
No,
but
and if
they
the states can spend money on it, the federal government can't. And the government, remember everyone, is not a revenue generating institution. They don't actually provide a product that we consume. And so the only way that they even have money to disperse and spend on things that they shouldn't be is through largely taxation. And then what they do is ultimately have these federal government programs that give so much money to the states that have strings attached. And so then the states give up more of their authority to the federal government that we, the people, didn't consent to. And so the legislature, I mean, this is an abrogation of their rights, just like how the Congress can't give any of its legislative authority to the executive. And the Supreme Court has recognized that that is a violation of separation of powers. In the same way, it's my opinion that the states cannot abrogate their authority and their power to the federal government just in return for a lot of these grants, because that is also a violation of the separation of powers. Because separation of powers is horizontal, but it's also vertical. And so we have to get back to not having these kind of ridiculous federal government strings attached grants to the states, and the states get to tax and spend on a state and local level, because then guess what? We wouldn't be spending and sending $40 billion to Ukraine. My home state of Colorado probably wouldn't do that, as liberal as they are right now in the state legislature. They wouldn't do that. Why? Because the people would vote them out of office right away and would say, what does Colorado have to do with Ukraine? Well, the very same question should be asked about the federal Congress, and why are they allowed to spend our money there? So we need to be looking at all of these things and making sure that we don't in any way manipulate these types of clauses as well. Like you said, Mike, the general welfare clause, that doesn't just mean that Congress can do whatever it wants and just arbitrarily put it, file under general welfare. It doesn't mean that.
Yeah, unfortunately, the Supreme Court doesn't agree. But, this Dobbs decision,
this new majority might.
Well, I sure hope so. I hope they listen to Justice Thomas. There's a lot of wisdom there. It is a big shift. But, 40 years ago, we would never have imagined that we would be here today. I think a lot of people feel that way. It is exciting to see this majority, doing such an incredible thing. I mean, the decisions in the last week and this week have been amazing. Conservative opinions, even though we can discuss these ideas of federalism, because when we consistently apply the ideas of substantive due process, it applies to things we like as much as things we don't like. And so we've got to be consistent. And we have to ask ourselves the question, what's more important? Is it more important that a few states get to decide that they want to have abortion, which I totally disagree with, and I'm excited that a majority of the states do not allow it. Okay. And a bunch of states have passed laws just in the last 48 to 72 hours, or had laws that were trigger laws banning abortion in their states. Are we as a republic okay with a few states doing things differently? Or do we have to be in lockstep? Do we have to have 5 individuals who wear black robes tell us what marriage means? Which when Justice Kennedy wrote his opinion in Obergefell, and I know the people on the other side are very upset and very concerned about Obergefell. They think that, this Dobbs decision is a domino. And, if we're going to apply this doctrine consistently, it should be, because 31 states voted and passed constitutional amendments to define marriage in their state. But there were other states at that time, New Hampshire, for example, Massachusetts, others that had recognized this in their state constitution or had passed civil union laws. I'm like, okay, if you don't like what a state does, move.
Right.
People are talking about, the Justice Department is talking about protecting the right of free travel for people who want to go and get abortion. I mean, I didn't realize we didn't have a right to travel.
Right.
I think we do. Why are they making an issue out of something that isn't an issue? Well, for political purposes. But we need to be consistent. And are we federalists, true federalists, or are we, for national government control over everything?
And that's an important point as well, because I've gotten a lot of questions over the weekend since the Dobbs opinion, just saying, well, why didn't the Supreme Court go further and say that there is a federal right to life and therefore ban abortion in all of the states? And while I would love to see abortion banned in all 50 states, it is a state issue. And so I can't advocate for judicial activism any more than the leftists should be advocating for judicial activism. As you said, Mike, we need to be consistent. And even though we may prefer for the majority of, the 9 robed justices to swing our way, we need to make sure that they don't harness any improper constitutional authority, even if we like the preferred outcome. And so we need to make sure that we are conservatives before we are Republicans, Democrats, or anything in between.
Well, that's true. And, the Alito's decision, again, lays out his rationale for overturning Roe. And he gives a very succinct and well-reasoned 5-step process for why he overturned it. And I would encourage the justices to follow that in all of them. I didn't see it in the Kennedy case where Gorsuch wrote the opinion and it essentially overruled Lemon, although I'm not sure if he actually said they were overruling
It wasn't
Lemon.
explicit, but if you go
Yeah.
in there, and I actually had to go through and read it before, and there was some question. I was like, did they actually overturn it? Because it wasn't as explicit as the Dobbs case saying we are overturning, Roe and Casey. But when they went through and when he actually read, and I would, for anyone who's actually reading these opinions, go to pages about 20 to 24 in Gorsuch's majority opinion, and that lays out that he did in fact overrule Lemon, which has fallen out of favor anyway. And let's talk about that test so that people who are kind of new to this constitutional law thing understand what we're talking about. This is a 1971 case, Lemon versus Kurtzman, that established basically a 3-pronged test for the government to determine whether or not there was a quote unquote entanglement with religion in violation of the Establishment Clause. But basically, in my view, Mike, and you may have a little bit different perspective, in my view, the main reason that Lemon was so difficult and actually unconstitutional was because it wanted to basically say we're discriminating against any religious exercise and the state has to be non-religious, which is an impossibility. And so it set up kind of this straw man that if anything was inherently religious, then the government can't be entangled with it. Otherwise, it's a violation of the Establishment Clause, which is ridiculous. And basically what Gorsuch said was our history and tradition and the plain reading of the Constitution suggests that the government can't discriminate against any religion or non-religious viewpoints in the very same manner. And so this case was rightfully overturned.
Oh, absolutely. All Coach Kennedy was doing was kneeling down and praying at the 50-yard line. He wasn't doing anything that a reasonable person would think is establishing a religion. And we talked about the fact that there were established churches, and this isn't really the Supreme Court's role to be micromanaging whether a coach can kneel at a 50-yard line to say a prayer after a game. I mean, that is where we've come as a country, folks.
So ridiculous.
This is not okay. This is not okay. We cannot continue down this path. We have to go back, and we have to, as people, as states, as local communities, we have to make these decisions ourselves. So we've got to support this continuing review and this idea that we've got to get rid of substantive due process. So no, the Lemon test, the excessive entanglement prong, there's a 3-prong test, and the third one, the excessive entanglement, was this idea that the courts would decide. And this is what Thomas said in his concurrence about Dobbs. It's like, look, we judges are not legislators. I'm paraphrasing, because what this does is it exalts judges over the people. Mm-hmm. And that's not what the founders intended at all. Look, when you look at the Constitution, Article 3, which sets up the federal judiciary, is like 200 words compared to like 1,000 words of Article 1 that sets up the federal legislature. Mm-hmm. So clearly they did not intend for the court to have that much power. And even when you read those who were in favor of the court in the Federalist 72 or 78, they said, look, the Supreme Court, the judiciary is going to be the weakest branch, guys. Hey, don't worry about it. Don't worry about the Supreme Court. Totally weak, no force, only judgment, which Alito and Thomas talk about. But yet it has become so powerful that it strikes down state laws, constitutional amendments. It federalizes all rights. No, that was never intended to be the case. We've got to go back to the way things were. Mm-hmm. And we've got to make these decisions on a state-by-state basis. And we've got to be comfortable living in a country that does things differently.
Mm-hmm. And it's so interesting, Mike, that we are comfortable with different states doing things differently on things that aren't these politically charged types of issues, because and one of the examples that I frequently use, because a lot of people are familiar with it, is the death penalty. So, for example, my home state of Colorado, the death penalty is still on the books and is still something that local Colorado state prosecutors can go through that due process element, and they can pursue the death penalty. And in other states, they don't have the death penalty. But that's not a conflict of laws in the sense of, oh my gosh, now there's, equal protection violations or anything like that, because we recognize that different states can do things differently, and they can establish their penal code for statutory punishment of criminal offenses in a variety of different ways. And so that's just one example of something that, and people have very strong opinions on the death penalty, and that's fine, they should. But we should be able to debate things in our own state legislatures and not worry about what another state is doing. And if I don't like what the state of Colorado is doing, I can move. That's why a lot of people moving out of California, they're going to the free state of Florida. That's a great example of federalism and of state sovereignty. So why is it, do you think, that in our common parlance, is it just because of the mainstream media? Is it because of sheer ignorance, or what is it that people think that we can't have a diversity of laws among the states because we all have to do the exact same thing in the exact same way if we all call ourselves Americans?
That is a really profound question, Jenna, and one I think we need to grapple with, because that's the essence of what our country was founded on. And we have gone off course. And that's where we've gone off course, this idea that we are a nation and we have to do everything in lockstep. And, when the federal government got the power to tax, and we got rid of, states appointing senators with the 17th Amendment, so nobody was there to look out for the state as a state at the federal level. We had this incredible federalization of everything. And then they all realized, well, we can do it. Let's do it. And, this is what the founders said. They said, when the people find out, this is in the Federalist Papers, that they can vote themselves money, we will have lost our republic. And that's what's happening. We're losing our republic. And, Alito said this in his decision, and I think this is exactly right. He said, it's time to heed the Constitution and return the issue of abortion to the people's elected representatives. I'd say not just abortion, but a whole host of other issues.
Yes.
And then he quotes Scalia, who says, the permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand. And that's what Justice Scalia argued for most of his life. And that's what we've got to do. And it's, I was talking with my neighbor the other day, did you know the Bill of Rights didn't apply to the states at the beginning? He's like, no, I never knew that. Why not? I asked him. Well, I wasn't taught it. Well, our children are not taught this in school. They're just taught that, oh yeah, the Supreme Court gets to decide. And that's right. That's just the way it is. That's not right. We as parents, we have to require this of our education systems, that people actually teach the truth. So I think that's a big part of it, is people just don't know.
Absolutely. And the education of Americans on what our supreme law of the land actually says and what it doesn't. And, Mike, you and I have talked about this a lot, where, I said, even in my book in 2015, in The Legal Basis for a Moral Constitution, when I describe in there how my own law school career and my own law school education, in constitutional law class, we started with just reading the Supreme Court's opinions. We didn't even read the text of the U.S. Constitution. So we're teaching even future lawyers who are supposed to litigate these issues and to advocate for the truth of the Constitution and for these important American concepts. We're teaching them that what the Supreme Court says that its authority is by definition correct. And this is now where you're getting to the idiots out there like AOC and others who are saying, oh, we need to impeach these justices because clearly they lied during their confirmation hearings when they said that, like she quoted Justice Barrett saying, Roe versus Wade is an important precedent in American history. Well, of course it is, until it was overturned. That's not a lie. That's simply saying this is a fixed point right now in American history, but the Supreme Court can reverse itself and should, and has an obligation to, when it was egregiously decided at its inception. And what people like AOC and the common mainstream media are refusing to recognize is that the text of the Constitution and our actual supreme law of the land is binding on the Supreme Court, and its opinions actually don't matter as much as what the text of the Constitution says. And it's not to say, like a lot of these other leftists who for the last 60 plus years are going, hey, it's the Supreme Court, you got to follow it, sorry, abortion's a right, what are you going to do about it? And now all of a sudden when the Supreme Court holds an outcome they don't prefer, they're like, meh, we're just going to ignore the Supreme Court. You can't do that and have a civil society if you tear down our institutions and our rule of law. But we do have to hold the Supreme Court accountable, just like every other branch of government. And this is where, you and I have talked about the Article 5 Convention of the States, because one of the things that I think our founders, may be the only one, that they didn't anticipate because they thought that the Supreme Court and the judiciary would be the weakest branch, is that they didn't have the ability to have states or any other branch of government be the check and balance on the judiciary. And so when we look at judicial reform, there should be a mechanism to at least vacate the precedential value of a Supreme Court opinion that was wrongfully decided. And obviously, that is a double-edged sword, because the states or whoever the power or the authority would be could then do something stupid like vacate Dobbs. So, how do we balance these types of questions and interests when we have a Supreme Court that maybe is returning things to the balance, but historically has been used to legislate from the bench arbitrarily and in an activist manner?
Well, that's the question we have to grapple with as a society, as a people, is how comfortable are we with the democratic process? People on the left love to scream about democracy, and rights, and it's my right, but are they really willing to engage in that hard work? And we're going to see, because what this decision does is it returns it to the states. And so there's going to be 50 state legislatures. There's going to be battles. I don't think this is going away. There's going to be a lot of discussion, a lot of debate in all the states. And so we have to ask ourselves, are we comfortable with some states getting it wrong in what our opinion is wrong, right? I mean, you go back and they say, well, Loving v. Virginia, where there was a law in Virginia that said black people and white people can't marry each other. I mean, there are equal protection issues there under the 14th Amendment, which, could apply. But the other thing about the 14th Amendment, Jenna, that I want to point out is Section 5 of the 14th Amendment says Congress shall have the authority to implement this section, this amendment by law. And so, our country gave Congress the authority. So if Congress wants to exercise authority, they have a lot of authority in the 14th Amendment to give effect to due process, equal protection. And so they can go after certain things like Loving v. Virginia. But sometimes it takes a little bit more work. I mean, Congress is inefficient, right? It's hard to get things through because there's so much that they're doing, because the government has become so big, part of the problem. But we have to grapple with that question as a people. Are we willing to, let some states feel their way along, and maybe there'll be some injustice that we'll have to right and work on? But is that better for us as a country? Is that a freer country where we have more freedom to make our own decisions rather than just deferring to what 5 black-robed lawyers think? As Justice Scalia he always loved to say, why does what 5 lawyers who wear black robes think matter in these matters of policy?
And
that's what we have to grapple with.
Ironically, it's the Democrats who continue to harp on we need to have direct democracy, we need to be a democracy. And then when you actually are giving the people the final say, which is an element of democracy in our constitutional republic, now all of a sudden they want the petty tyranny from the 5 robed justices. I mean, it's so ridiculous, because it's showing that all they care about is their preferred political outcome. They don't want to have these difficult debates. They don't want to have to actually say, well, where do you think the right to abortion actually comes from? Why should that be a right that's recognized as God-given? Why is that a right any more than a so-called right to go out and electively choose to intentionally murder someone else? Why? And have these kinds of debates and have these discussions and have the very difficult, as Alito recognized, moral conversation, because law is inherently moral, and it is so much more difficult to convince the legislatures of 50 states than just an arbitrary whim of 5 robed justices. But I want to go back to something that you just said about the 14th Amendment and Clause 5, because I want to make sure that people aren't confused by that, in the sense that, there is authority given to Congress there. But if Congress were to try to, for example, make a federal rule for abortion, saying, well, that's part of equal protection, of women or whatever, my view would be that would be just as unconstitutional, because that's not really what the 14th Amendment gave Congress authority for. Am I wrong?
Well, right. So we have to go back and what's the original meaning of the 14th Amendment, which Justice Alito unpacks. And, we have to look at it. What did the word liberty mean at the time the 14th Amendment was ratified? What did life mean at that time? What did, property mean at that time? And when you talk about a federal rule for abortion, I mean, they tried to do it. They couldn't get it through the political process. So, that's the political process happening. And I don't think that would work on that issue. But there may be other issues that it would work on. For example, the Loving case that I talked about before. I don't want people to get the wrong idea that I think it's okay for a state to say a black person can't marry a white person. That's ridiculous.
Right.
I believe that we are all members of one race, the human race, and everyone should be treated equally. So that would be a situation where I think at that time, that's what Congress was intending, that all people should be treated equally, no matter what the color of their skin was, no matter what their previous condition of servitude had been, whether they were slaves or not. And so, we'd have to address each of those issues as it came up. And that is, what the 14th Amendment did is it, under Article 3, the Supreme Court can review cases and controversies. The 14th Amendment gave Congress authority to pass laws to give effect to that 14th Amendment. So they can try and pass laws. Then we can have a debate, and we might have to have that debate in court if things go through Congress that we don't agree with.
Right. And it's certainly not open-ended to just say that, just like the general welfare clause, to say, okay, just because Congress has the ability to give effect to some of those areas, that doesn't mean now that that Congress can use the pretext of the 14th Amendment to just try to pass through any law that it wants under that banner, just like the general welfare clause. So, so that wouldn't work in the same way. And so, so like you said, even though the 14th Amendment, we have to go back to what did it mean at the time? What was the purpose? It's the same thing as the 1964 Civil Rights Act. When Congress wrote the term sex, they definitely were not talking about sexual orientation and gender identity. That can't be read into it now just by virtue of a Supreme Court majority that wants to read into it, or a Congress that wants to read into it. Congress would have to pass a completely different law.
That's a really good example. I think you articulated that really well. And, of course, Congress can do whatever they want to do, and they do. So we just have to kind of watch them very carefully and exercise our involvement in the political process. And when things go through, we do have recourse to the courts. There is a place for the federal judiciary to review, especially acts of Congress relative to its power under the Constitution. And the Supreme Court has let Congress get away with so much. I mean, you talked before about delegating their legislative authority. I mean, they shouldn't do that, but they've been able to get away with it, which is why we have the administrative state. And that with a taxing authority, they can fund them to the tune of billions of dollars. And they just are running rampant all over our country in so many places we don't even know where, interfering with our rights to conduct our lives as we see fit without having to jump through their hoops. That's a problem.
So Congress can do whatever it wants in the sense that it can try, but it can't legitimately do whatever it wants. And that's where a good judicial branch will keep the two political branches in check. So in just the last few minutes that we have here with you, Mike Donnelly, so where do you think that this argument for abortion needs to go? And what is the best argument to the state legislatures to say, hey, we need to restrict and outright ban all abortion? Because, I mean, that's would be my argument in front of a state legislature to say, hey, follow the science. Life begins at conception.
Well, I certainly believe that as a Christian. And, I believe that, unborn human beings are the most vulnerable person you can imagine. And as a class of people, they deserve protection, which is one argument that some people are going to make when they come to the courts and say, hey, you need to define life as a matter of federal law. Okay. So I'm not saying I'm not saying that, but that I think is what is going to happen. But I do think that at the state legislature, and that's the issue. When do you believe life begins? If life begins at conception, how can you not protect it? How can you not find other ways to help women in bad situations? I mean, look, I know that. I mean, I understand there are these situations that happen that are tragic. Jenna, you understand these situations that happen, and they're terrible. They're tragic. And we've got to help people in those situations where there's a situation of rape or other kinds of criminal activity that results in the conception of a human life. But killing someone, that can't be the solution.
Yeah.
It can't be the solution. And so we've got to put our national creativity, and boy, this country has it in large amount. We've got to figure out ways that we can help people who find themselves in those situations. We've got to work to help people who cause those situations through criminal reform and working in schools and helping families and encouraging families to be places that teach true moral principles. And look, it's a fallen world. We're all sinners. We all need a savior. And ultimately, that's what I think we've got to reach out to our fellow citizens and say, we're all sinners, but there is hope. We can find that hope in God, and at the very least, we have to protect these people who are people, these unborn children, and find ways to not politicize this, the ending of their lives,
Yeah.
which is happening. So
And-
that's what I hope we can do.
Yeah, and so well said. And just like our founding fathers said, I mean, our Constitution was only built for a moral and upright people. It's wholly inadequate to the governance of any other. And what they meant by that is that we have to be willing to engage these moral debates, and not just from a place of, well, this is my faith I'm imposing on you, but saying there is objective moral truth that is self-evident, and we all have to recognize that under a unanimous declaration. I mean, the unanimous declaration, those three words came before we the people. And it's only under the unanimous declaration of recognizing self-evident truth that it's God who gives us our rights, and recognizing God as the supreme judge of the universe, that we can have, we the people, and we can have the ability to have and debate all of these concepts and debate what is truth and seek truth. But that's what we need to be willing to do, is to seek truth and then act on it without some preconceived political outcome that's determined, just based on what the leftist fantasy is and what they would prefer reality to be. We can't, as human beings, arbitrate or create our own reality. We are limited to the reality that God ordained. And so we as Christians need to be willing to make those arguments, and we need to be willing to make them not just on a position of, well, this is what I believe, but this is what the truth is. It's not my truth versus your truth. It is the truth. So we'll continue to talk about all of these great concepts. And I'm so excited that Salem gave me a platform to have these conversations, because that's exactly what it's all about. So let's debate and discuss these things. I love hearing from all of you who listen to this show. So definitely subscribe wherever you listen to the Jenna Ellis Show, whether it's on Rumble or on the audio stream. And thanks so much, Mike Donnelly. And where can people find you and send their kids to Con Law Camp? And you also have a podcast.
I do have a podcast. My full-time job is as an attorney with the Homeschool Legal Defense Association. So people can go to hslda.org to learn a little bit more about our organization and what we do. And at Patrick Henry College, phc.edu, is where they can learn more about our constitutional law camp. And Patrick Henry College is committed to equipping the next generation of Christian leaders in a manner that is based on biblical values and that is true to the founding. So if that's the kind of education that you want for your children, I really hope you'll take a look at Patrick Henry College as a place where you're a young person might want to come. It's a small college, but it has a big voice, especially in moot court, where they win all the time in the college moot court. And it's just a great place for kids to learn. Thanks for having me on, Jenna. Great to see you. Great talking with you, and God bless you all.
Great to see you too, and look forward to more conversations and having you on again soon. Thanks so much. Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And when and we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903. I also want to talk about another great American who is the sponsor of this podcast, and that, of course, is my good friend Mike Lindell. He has been canceled out of so many box stores for simply standing up for his own political opinion. And disagree or not, or support him or not, it is a fundamental right of every American to be able to voice their opinion, and that absolutely includes politics. That absolutely includes issues that are central to our culture. That includes faith. Mike is such a very sincere Christian, and I am proud to consider him a friend, and he is, of course, a friend of this show. So right now, there is a special on MyPillow.com. Click on the new radio listener specials. Get deep discounts on all MyPillow products, including a great towel set, which is a 6-piece set. It includes 2 bath, 2 hand towels, 2 washcloths, made in the USA, regularly $109.99, now just $39.99, but you have to use the promo code Jenna. That's Jenna. That tells Mike that you listen to this show, you're happy that he is a sponsor of this show, and you will get great discounts, but use the promo code Jenna, that's Jenna, either at mypillow.com or call 1-800-564-8475 and use the promo code Jenna.